through the parliamentary process.
Call Kevin Haig.
Thank you, Mr Speaker. Can I begin by congratulating you on your reappointment and also congratulating Minister Tremaine on his first piece of legislation before this House in his ministerial capacity. I'm rising to speak in support of the bill today for the Green Party in the place of my colleague Mojo Mathers, who will lead the Green Party's further work on this bill. But sadly, the technology is not yet in place to allow her to participate fully in this debate, and that's a matter, I think, for regret and hopefully rapid remedy. We support the general intent, clearly, of a bill like this to modernise and rationalise legislation and introducing things like standard definitions, covering sales processes that were not even conceived of at the time that some of this legislation was put in place. So credit cards and internet sales and various of those things. I think Leanne Dalziel mentioned the fact that some of the legislation this replaces is almost a century old, and the Auctioneers Act of 1928 probably is overdue for a bit of an overhaul. We support the new provisions being included related to unsubstantiated representations. I think it's very important that consumers should get the full facts and draw attention to a particular use of the new provisions in relation to greenwash. And we hope that this bill, when enacted, will see a reduction of that pernicious practice. There are far too many examples of people seeking to benefit from association with the qualities of environmental friendliness or ethical value without the expense involved in making their claims real. I'm not sure, sir, if this legislation will extend to political parties in that regard, but certainly that might be a matter the Select Committee could consider. We also support in particular the aims of the legislation regarding product safety. The Ministry of Consumer Affairs warned the Minister back in 2009 that these product safety risks were on the increase and that there was an international consensus requiring some more effective action. In 2007, the United States Consumer Product Safety Commission oversaw the largest annual number of voluntary product recalls in the last decade. At the same time, the European Commission reported a 47% increase in notifications of product posing serious risks to consumers, with half of those products originating in China, a country with which we now have a free trade agreement and a burgeoning import trade. The Ministry's report said New Zealand's current model was skewed toward rapid reaction to incidents rather than taking a more proactive approach to emerging risks. Well, this legislation, I don't think we could accuse it of being a rapid response or rapid reaction, but at least it is finally in the House. Consumers have a right to know that the goods that they are purchasing are safe and that they and their families will not be injured through dodgy appliances or products. We also support the strengthening of rules around direct sales. We're pleased that legislation is finally tackling the scourge of the uninvited salesperson. Legislation sets out rules for uninvited direct sales and repeals the Door-to-Door Sales Act 1967. We also believe that that consumers deserve protection from unfair contract terms, and I was very interested in the Minister's comments about that. I'm very pleased to see that he is intending and directing the Select Committee to take a look at re-inclusion of those provisions in the bill. It's a great shame that the government did not do that in the bill that we're considering today, because protection from unfair contract terms buried in small print is one of the principal problems that in fact consumers face. And New Zealand's biggest consumer advocate group, Consumer New Zealand, has been particularly critical of the decision to omit that provision from this bill. Government's reasons for omitting that are far from clear, and certainly the Minister and Mr Macleay speaking to the bill today didn't make it clear why those provisions had been dropped. And we believe that there's certainly a strong case for following Australia's lead and making it easier for consumers to challenge those unfair contract terms in standard agreements for things like car rentals and gym memberships, which are some of the examples that have recently been in the news media. We don't suggest that New Zealand should slavishly follow Australia's lead, but this does seem to be an area where harmonisation would benefit New Zealanders. The terms in contracts are typically contained in pre-written standard form contracts, often dense fine print, which the former Minister of Consumer Affairs accepted was sometimes one-sided and usually signed by consumers without reading. And sometimes those contracts are signed by some of the most vulnerable in our community, with perhaps poor English language skills, elderly or disabled. And it's a great shame that provisions protecting those groups have not been included in the bill at this time. But as I say, it's good that the Minister is intending that they will be considered by the Select Committee. I note with interest that the Direct Selling Association of New Zealand vigorously opposed including an unfair contracts provision in their submission to the Ministry for Consumer Affairs on the discussion paper. And I do hope that that was not the submission that swayed the government to exclude those terms. The reasons the Direct Selling Association gave were that such provisions would add to compliance laws and that existing laws were already adequate. And I think that's probably something we've heard on a number of occasions. And I think most New Zealanders would disagree with that statement, and certainly the ongoing popularity of the Fair Go television show would indicate otherwise. We also share TradeMe's concerns that professional traders are not forced by this bill to disclose themselves as such. And I would hope that the Select Committee will also look at that matter. It seems a missed opportunity that the Consumer Affairs Ministry considered including a requirement for professional traders to disclose that fact, but that it has been excluded. Traders who identify themselves as professionals could then more easily be held to legal obligations, including the requirement to offer refunds on shonky goods and to pay tax on their profits. The Arthur Dailies, of this world are no longer selling second-hand motors and brown leather jackets from lockups. They're now online, and TradeMe's recommendation, I think, should be taken very seriously. The former Consumer Affairs Minister, John Boscawen, said the issue of identifying professional traders could be looked at again at the Select Committee stage, and I urge the current Minister Tremaine to do so. So the fact is that most businesses are fundamentally concerned with profit maximisation, and indeed probably all should be. And one maximises profit by maximising sales and minimising costs. And at the same time, that profit motivation is probably universal amongst businesses. The ethical standards that go with that are not necessarily universal. And so while some businesses may have a business model that relies on long-term relationships with customers and repeat sales, others have a business model that relies on one-off sales. And the temptation to take shortcuts and to mislead consumers if they believe they'll get away with it is one that many businesses are shown to often take. And I think it's very important that this bill does protect consumers from that. I was very heartened to hear the Minister's comment about the government's commitment to improve the quality of regulation in this field and in others, I hope, sir.
Ko Kanwaljit Singh Bakshi.
Mr. Speaker,